Assalamualaikum and hi to Dr. Hartini. In this video, we will be presenting the family law assignment. Our group consisting 7 members, and for the case study, we have chosen question number 1. So let's get started. The case is about married couple. Raj and Sheila were married in 1985. From their marriage, they have 4 children. But first, allow me to introduce their children so that we get a better understanding about this case. The first child is a boy aged 20. He is studying at Leeds University in United Kingdom. While his sister, the second child, aged 16, she is studying at the boarding school in Johor Bahru. The third child, a boy aged 13, has all along been staying with Raj's parents in Johor Bahru. And the youngest child is a boy aged 6 months, is with Sheila and he is still breastfed by Sheila. Both Raj and Sheila work hard to improve their standard of living. 5 years ago, Sheila decided to sell her car given to her by her father to provide capital for her husband's business. With the assistance of Sheila's father, Raj's business prospered and he achieved the status of a successful businessman. Both of them accumulated a lot of wealth and they own a number of houses, 2 pieces of industrial land, 3 luxury cars and 100,000 worth of shares. However, recently Raj met Nadine, an actress, at an official function and he fell in love with her. And ever since then, there was no more understanding between Raj and Sheila. Raj even plans to divorce Sheila to enable him to marry Nadine. So, regarding the divorce, there are few issues arose. So the first issue is whether Sheila can claim all the above mentioned property, as she also has the contribution in those property. Generally, distribution of property can only be made under 2 situations, namely upon a divorce or dissolution of marriage or upon death. In the matter of divorce or dissolution of marriage, distribution is in respect of property acquired during the subsistence of a marriage between a man and a woman, or if acquired prior to the marriage, the property has been substantially improved during such marriage. These situations falls under dissolution of marriage or divorce, where the law can be referred to Section 76 of Law Reform Marriage and Divorce Act 1976. Technically, this section is about matters incidental to matrimonial proceeding. It has been stated that whether jointly or solely acquired, the court will incline towards equality of division of any properties acquired during the marriage, while taking into several considerations. Section 76 Clause 2 Clause A mentions one of the considerations, which is the contribution made by each party in money, property or work towards the acquiring of the properties. Section 76 Clause 5 also can be taken into account as the properties acquired during a marriage include properties owned before the marriage by one party which have been substantially improved during the marriage by the other party or by their joint efforts. There are few cases that can be referred. In Evelyn Tan versus Tan Lim Tai, the court held that the plaintiff wife had made substantial financial contributions towards the acquisition of the joint matrimonial home and concluded that it was the common intention of both spouses that they should share the house at least in equal shares, even if the house was registered in the husband's names. Opposed to this case, there is the case of B. Ravindran Balan versus Maligamani Pillai. So in this case, both of the parties had contributed to the purchase of the matrimonial home as the respondent also contributed substitutionally towards the purchase of the matrimonial home and paid for the monthly installments, taking into consideration the contribution of the petitioner and the needs of the children. It would not be appropriate to transfer the whole of the matrimonial home to the respondent. So the court held that the proper order was that the status quo remained and the matrimonial home could be sold when the children attained majority and the proceeds to be divided equally between the parties. Alright, applying the above case to the present situation, Sheila has sold her car given to her by her father to provide capital for her husband's business during their marriage, and had contributed substantially in the properties above mentioned. So according to the case of Evelyn Tan, Sheila may claim half of all the properties as it is a joint property. This is because the above mentioned properties were acquired by Sheila and Raj during the marriage and on their joint effort, with each of them contributing towards the asset. Furthermore, this situation obviously relies on Section 76 of LRA 1976, as the court will incline towards equality of division of any properties acquired during the marriage, whether jointly or solely acquired, as this fact have met the relatable consideration. So this shows that Sheila is also entitled to half of the interest in the matrimonial properties. In conclusion, Sheila can claim her share in all of the above mentioned properties, as she is also entitled to a share of the house for which she had contributed substantially of the purchase price. Moving on to the next issue is whether Sheila can claim custody of her 4 children. In determining whether both parties that have been divorced have the custody of the children and wanted to claim the custody, some factors need to be seen. According to Section 88 Clause 1 of the LRA, courts can make the decision either to put the children under the custody of the father or the mother at any time. In Section 88 Clause 2 of LRA, the welfare of the child will be the court's top priority when determining custody. Therefore, the court will evaluate a number of considerations before making a decision. Section 88 Clause 3 of LRA provides that there shall be a rebuttable presumption that it is for the good of the child below the age of 7 years to be with his or her mother, but in deciding whether the presumption applies to the fact of any particular case, the court should have regard to the undesirability of disturbing the life of a child by changes of custody. Section 88 Clause 4 of LRA stated that the welfare of the 2 children has to be assessed individually while awarding the custody. So, let's take a look on few cases. In the case of Saraswati versus Balakrishnan, the court held that the phrase "at any time" means the application may apply for and the court may order custody of a child without needing to wait for a divorce action being commenced. As provided in Jayakumar Karupanan versus Jayakumar Krishnan, the court considered the wish of the child to live with his maternal grandparents, and the court ruled that to separate them would be detrimental to the child's physical and emotional development. With reference to the case of Ku Chingni versus Lu Bingqiu Pao Sing, it was held that the children at the age of 10 and 7 were still at the age when they could not determine what they really wanted and could be easily persuaded. In Chu Ziho versus Tan Pik San, the presumption under Section 88 Clause 3 had not been rebutted by the husband, and after considering the natural law that custody of the child below 7 should be given to the mother, the custody was granted to the wife. And the court in Chang Ahmei versus Francis de Tiensa awarded the custody of the child to the mother as the child had stayed with her mother more than the father. Applying the law to this case, Raj and Sheila were married and living together for a long time. Sheila wanted to claim custody of her children as there was no more understanding between Raj and Sheila, and Raj wanted to divorce her to marry another woman. So therefore, Sheila can apply to the court to claim custody of her children without being divorced first. In this situation, child custody after divorce should prioritize the right, interest, and welfare of the child. For the court to determine the custody of the children after divorce, the parties have to be domiciled or physically present in Malaysia, where we can assume that both parties have been living together at Johor Bahru. Applying Section 88 Clause 4, every child of Sheila's needs to be decided by the court in awarding custody. For the first child, he is aged 20 years old. Therefore, he is an adult who is at the age where he is capable of determining what is the best for his well-being and could reasonably express an independent opinion. Thus, he can choose whether he wants to stay with her mother or his father. If he wanted to stay with his mother, therefore, Sheila can claim for custody. For the second child, aged 16 years old, she is still studying at a boarding school in Johor Bahru. In this situation, she also has attained the age where she can determine what is the best for her well-being. Therefore, she also can choose to stay with either her mother or father. If she wanted to stay with her mother, therefore, Sheila can also claim for custody. For the third child, a boy aged 13 years old, he has all along been staying with Raj's parents, who are his own paternal grandparents in Johor Bahru. Applying the case of Jayakumar Karupanan versus Jayakumar Krishnan, we can assume that the third child wanted to stay with his grandparents. Therefore, a presumption should arise that he would be better off with them unless he wanted to be with his own mother. And last but not least, for the youngest boy, aged 6 months, he is still a toddler and definitely below 7 years old. Therefore, he is still at the age where he is incapable of determining what is the best for his well-being. Other than that, the boy needs her mother's love and care as he is still breastfed by Sheila. Therefore, by applying Section 88 Clause 3, custody should be given to Sheila as a mother to him. Hence, it is most likely to conclude that Sheila has the right to claim the custody of her children by fulfilling all of the conditions. The last issue to be discussed is whether there are any relevant grounds available for Raj and Sheila to dissolve their marriage. Section 48 Clause 1 of the LRA provides that the court will have jurisdiction to make a decree of divorce only if A. The marriage has been registered or deemed to be registered under the LRA, or B. The marriage between the parties was contracted under a law providing that or in contemplation of which marriage is monogamous, and C. The domicile of the parties to the marriage at the time when the petition is presented is in Malaysia. Section 50 Clause 1 states that the court will not grant any petition for divorce before the expiration of the period of 2 years from the date of their marriage. Section 52 provides that when a couple mutually agrees that it is in the best interest that their marriage should be dissolved, they should be allowed to do so quietly without discrimination and unnecessary publicity in a quarrel. Section 52 also requires that proper provision be made for the wife and the support, care and custody of the children of the marriage, and this proper provision must be freely agreed upon by the court as fair and reasonable before the decree of divorce can be granted. In the case of Ong Ahmai versus Ling Poi Ming, from the clear wording of Section 52 of the LRA, mere mutual consent is sufficient grounds for divorce, where, when the spouses had mutually agreed to dissolve their marriage, the court had no power whatsoever to inquire into the adequacy of the reason for the joint petition because the satisfaction of the court was not related to the basis on which such mutual consent had been reached. However, the court only had the powers inquiry of the consent and provision made for maintenance and custody of children. To apply this case, there are three ways of obtaining a divorce under LRA, which are divorce by conversion to Islam, divorce by mutual consent, and divorce by way of breakdown of the marriage. Based on the fact of the case, the best way of obtaining divorce is through divorce by mutual consent. Raj and Sheila have been married for more than 2 years, so they fulfill the time frame to qualify for a petition under the sections 52 and 50 clause 1 of LRA. To apply this ground of divorce, free consent from Raj and Sheila are needed. Proper provisions needs to be made for Sheila and the support, care and custody of their children. Raj and Sheila can reach an agreement together to dissolve the marriage as there is no more understanding between them and send the petition to the court. When the proper provision made is fair and reasonable, the court will grant the decree of divorce. By doing this, Raj then can marry Nadine. And Sheila, on the other hand, will get her right fairly and live happily with her children. To conclude all, there is a relevant ground that is available for Raj and Sheila to dissolve their marriage, which is by mutual consent. In a nutshell, everyone gets their own rights and treated fairly by law. As for that, I think that's all from our group, and thank you so much for listening. Bye!